Welcome back to the Supreme Court of the United Kingdom. Today we are hearing the appeal in the matter of A and B against the Criminal Injuries Compensation Board, and we're hearing the submissions by Mr. Collins, Queen's Counsel, on behalf of the respondent. Mr. Collins.
Well, thank you very much. And I was going to go on to start with the question of ambit, the starting point for which is not in dispute. And it's that in order for the appellants to be able to rely on Article 14, they must, of course, show that the subject matter of their claim falls within the ambit of a convention right, in this case, Article 4. And in order to do that, they must show that the measures in question have a meaningful or more than tenuous connection with the core values protected by Article 4. The measures in this case being the availability of state compensation for injuries sustained as a direct result of a crime of violence, as set out in the 2012 scheme. And just in terms of the approach to take, I can just take the court to a couple of authorities very quickly. First of all, page 1362, which is M and the Secretary of State for Work and Pensions. This is from the opinion of Lord Bingham, down at the bottom of page 1362, paragraph 4. It's not difficult when considering any provision of the Convention to identify the core values the provision is intended to protect, but the further a situation is removed from one infringing those core values, the weaker the connection becomes until a point is reached when there is no meaningful connection at all. And of course, one of the questions for this court will be whether or not that point has been reached. Is there a meaningful connection? How does one decide that? Well, one approach was set out by the Master of the Rolls in Smith and Lancashire Teaching Hospitals, page 2380. That's within paragraph 55, right at the top of the page. And it says this: if the state has brought into existence a positive measure which, even though not required by the article, is a modality of the exercise of the rights guaranteed by the article, the state will be in breach of Article 14 if the measure has more than a tenuous connection with the core values protected by, in our case, Article 4, and is discriminatory and not justified. And of course, the appellants place heavy emphasis in this appeal on the proposition that the scheme is a modality of the exercise of rights guaranteed by Article 4. And we say that really goes too far, and we say it's wrong. But we note the appellant also says that there's a positive obligation to award compensation in circumstances such as these. I noticed my learned friend put it orally this morning on the basis that there was a positive obligation under Article 4 to provide access to a compensation scheme. And if that were as high as the appellants went, that would be the end of it, because the courts below have already held that access has been provided to the scheme, and there's been no permission granted in relation to that. But as we apprehend it, the appellants go further and they say actually there's an obligation to provide compensation in circumstances such as these. And we say that's wrong also. And the court's already seen from this morning's submissions that the starting point for considering the state's positive obligations in a case such as this, a case of human trafficking, is the case of Rantsef. And I know the court's seen it already this morning, but can I ask you to turn back to it so that there's some submissions that I need to make about the structure of the judgment. And could we have a look, please, at page 3146? And this is the start of the passage within Rantsef, where the court gives its assessment, and it's a number of these paragraphs that you were taken to, I think, not from this judgment itself, but they're reproduced in SM and Croatia. So that's where the court saw them this morning. But what I wanted to make clear was this part of the judgment, which starts at paragraph 272, is all about the question whether trafficking is covered by Article 4 at all. And one can see there's the whole of that page, and going over to the next page is all exploring that question. It's not looking at what the positive obligations are or what the extent of those obligations may be, considering a preliminary question, whether human trafficking is covered by Article 4. And the conclusion you've seen is paragraph 282 on the next page. And your attention was drawn, I think orally and certainly in writing, and the intervener drew this to the court's attention, that there are references there to the Palermo Protocol and the Anti-Trafficking Convention, to ECAT. And what is important to note there is that the court is using the definition of trafficking taken from ECAT, but it hasn't felt the need to rely on those conventions to decide whether or not trafficking was covered by Article 4. It's reached that conclusion on the basis of, and one can see this from the third line of the paragraph, on the basis of its obligation to interpret the convention in light of present-day conditions. And the same approach, in fact, is taken in SM and Croatia. I'll come to in just a moment. I don't ask the court to turn it up immediately, but the court says there, because trafficking is not defined in Article 4, the definition of it is drawn from other instruments. But it doesn't help us with what Article 4 requires and what Article 4 covers in relation to the victims of trafficking. The next part of the Rancef judgment is of a little more assistance so far as that's concerned, under the heading General Principles of Article 4. It's linked there with Articles 2 and 3, those three articles enshrining some of the most basic values of democratic societies. But one then sees the requirements of Article 4 identified at paragraphs 284 and 285, and the court's already seen this, so I'll take it quickly. It identifies requirements for safeguards in national legislation, criminal law measures, business regulation, immigration rules, all identified at 284. And then at the bottom of 285, one sees what the intervener refers to as the trilogy of obligations. The last but one line, in fact, 3 lines from the bottom, the Anti-Trafficking Convention refers to the need for a comprehensive approach to combat trafficking, which includes measures to prevent trafficking and to protect victims, in addition to measures to punish traffickers. So the 3 important features of the obligation: prevention, protection, and punishment. And then the court goes on over the page at paragraphs 286 and 287 to identify the need to take operational measures to protect victims. And at 288, like Articles 2 and 3, a procedural obligation to investigate. And that's the part of the judgment which explains the positive duties on the state. And the obvious matter to note, we say, is that there's no mention here of state compensation. Rancef refers to an earlier case called Siliadin. And I ask the court to look at that next. 3197, please. 3197. Another trafficking case. Paragraph 89, about a third of the way down. The court considers limiting compliance with Article 4 only to direct action would be inconsistent with the international instruments specifically concerned with the issue, and would amount to rendering it ineffective. It necessarily follows governments have positive obligations in the same way as Article 3. And I'll come back to that because we, of course, rely on Stewart, which is an Article 3 case. And we say the articles can be treated essentially in the same way for these purposes. obligations to adopt criminal law provisions which penalise the practices and to apply them in practice. And then at 3199, a couple of pages down, paragraph 112, it's near the bottom of the page. That falls in 2 paragraphs. The second says that the member states' positive obligations under Article 4 must be seen as requiring the penalisation and effective prosecution of any act aimed at maintaining a person in such a situation.
I'm sorry, which paragraph is that, Mr. Collins?
It's 112.
Yes.
But it's the second part of 112.
Thank you.
That takes me on to SM and Croatia, and we start, please, at 808. Again, the court's seen this, so I'll take it as quickly as I can. Again, the section which starts at paragraph 279 is all about whether trafficking falls within the scope of Article 4 at all. And that takes us right through from 808 to 815. I won't ask the court to go through all of it. But as we come to 815, one can see the conclusion at paragraph 303 that human trafficking falls within the scope of Article 4. So everything that goes before addresses that question. The issue of the positive obligations under Article 4 starts on page 816, the next page. So when you consider the appellants and interveners' submissions on the earlier paragraphs, we ask you to bear that in mind. Those paragraphs aren't about positive obligations. They're about the extent of the application of the convention. And then the court has seen paragraph 305 and that extensive citation from Rantsev. And at paragraph 306 identifies the duty to put in place legislative and administrative framework to prohibit and punish trafficking, a duty to take operational measures to protect victims, and a procedural obligation to investigate. And one can see from 307 it was the obligation to investigate which was an issue in that case. But again, no mention of compensation. And really the high point of the Strasbourg authorities, so far as the appellant's case here is concerned, must be Chowdhury, because that does at least mention compensation. And I ask the court to turn, please, to page 729, which is where the section in Chowdhury starts on the respondent states positive obligations under Article 4. And what one sees just below 104 is that the first part of that was the obligation to put in place an appropriate legal and regulatory framework. That's considered over the next page. And then there's a section at the bottom of page 730, which deals with operational measures. And at the bottom of 731, just above paragraph 116, one sees the heading effectiveness of the investigation and judicial proceedings. And the paragraphs of Chowdhury that you're referred to in this appeal all come under that heading. Quite a lengthy section, but the passage that you've been taken to is on page 734, still under the same heading, paragraph 126. And this is where the appellants derive their propositions about compensation from the authorities from, because the court made a finding that even though the individuals were found guilty of grievous bodily harm, they were only ordered to pay compensation of €43 per injured worker. And you see the reference there. It says, however, Article 15 of ECAT obliges contracting states, including Greece, to provide in their domestic law for the right of victims to receive compensation from the perpetrators of the offence and to take steps to inter alia establish a victim compensation fund. The words inter alia there may be rather important because, as my Lord Stevens observed this morning, 15.4 of ECAT doesn't set out mandatory requirements as to compensation. It makes some suggestions and gives some examples. But of course, the appellants highlight the reference here to a victim compensation fund. In response to that, we observe this. Firstly, this is a passage about an effective investigation and judicial procedure. The court plainly reached the conclusion that there was not an effective judicial procedure, and the derisory compensation was a feature of that, albeit that this paragraph, in terms of how it appears in the judgment, appears to be something of an afterthought. The Court of Appeal described it in this case as an adjunct to its findings, and we suggest that's a fair way to approach it. Secondly, we observe that insofar as this paragraph deals with compensation at all, it deals with compensation from the individual, not from the state. And thirdly, we observe that although Article 15 is quoted, there's no commentary on it. It's simply cited there. And what we suggest is that the paragraph does no more than identify that a proper judicial and investigatory process should have regard to the possibility of proper compensation. What it doesn't say, and as I understand it, the appellants accept this, it doesn't say that the terms of ECAT must be in some way transposed into the requirements of Article 4. There's no authority for that proposition. We accept, of course, that in interpreting the convention as a living instrument, the court will have regard to international norms. That's apparent from the authorities referred to. But that falls far short of showing that because compensation is addressed in ECAT, it must be a modality of discharging the positive obligation under Article 4. None of the authorities say that. And indeed, the Court of Appeal, in one of the authorities that the court's got, H, and the Secretary of State for the Home Department, says in terms that the obligations under ECAT are not read over directly into the procedural obligation under Article 4. I won't take the court to it for reasons of time, but the reference is page 2339, it's paragraph 41.
But the crucial question is, where is the Strasbourg court going? And what it's done is to lay down a fairly clear marker that it's going to judge what states do by reference to what's in ECAT. Now, maybe they don't have to follow it to the letter, but they are expected to provide something equivalent. And what 126 and 127 are perhaps saying is that there wasn't a proper procedure in this case to give compensation because of the derisory sum offered for all the victims. And perhaps Ms. Kaufman was perhaps going too far in saying that 127 did not follow from the relevant part of 126. It doesn't matter how you provide the compensation. If you choose to provide it through a court award, then that's fine, but it must be a proper award. See the importance placed on compensation by the ECAT itself, and that they're using ECAT as a benchmark for what might well turn out to be positive obligations of the state, but they're using it in this case simply as a benchmark whether the compensation was adequate.
I'm sure that's right, that what's been looked at by the court in this case is whether the judicial process was effective by having one eye on ECAT, which undoubtedly gives some guidance as to the sorts of approaches which might be reasonable and appropriate. 15.4 sets out some examples, and I've no doubt my lady's right to say that if the compensation had been dealt with properly, then the court might have reached a different conclusion. But I certainly would respectfully agree that the question is where is the, I think my lady started by saying the question is, where is the court going? But perhaps I can take it back a step. Where has the court got to thus far? Because we respectfully submit that the court has not got close to saying that the payment of state compensation for the consequences of the acts of individuals is a modality of the exercise of Article 4 rights. We respectfully suggest that for this court to make a finding along those lines would be breaking new ground. That would be forging well ahead of where the Strasbourg jurisprudence has got thus far.
But would you accept that if you could get adequate compensation from the traffickers, the convicted traffickers, there would be no need for the state to have a compensation fund? It's only when the traffickers are not good for it that you have to have some fund to back it up in order to help the victims of trafficking get back to normal and to become integrated in society, which is the objective.
My lady, two aspects of that are absolutely right. First of all, it's right to say that the issue of state compensation arises in the first place because of the difficulty of getting compensation from the traffickers themselves. That's apparent from a number of the documents, and it's perhaps obvious as well. But secondly, the proposition that the purpose of all of this is to assist the traffickers to get out of the position that they have found themselves in is correct, and that's what comes out of a number of the dicta in these cases, talking about the requirements not only for punishment and prevention but also for protection. And the cases do identify that support is necessary to get these people back on their feet in many cases, and I'll come on to deal with how that works in the UK in due course.
But compensation is part of getting them back on their feet. That's why the ECAT is interested in seeing that they get some form of compensation.
Well, it may be, my lady, and it isn't necessarily in every case. And I'll come on to deal with what we're looking at in the present case. And criminal injuries compensation, we say, does not properly fall within this rubric of the sort of assistance that is provided to assist the victims of trafficking in that context. I'm just so sorry for hesitating. I'm sure there's a dictum in Chowdhury which helps. Just for your note, my lady, paragraph 110 of Chowdhury on page 730 says in terms, protection measures include facilitating the identification of victims by qualified persons and assisting victims in their physical, psychological and social recovery. Those are the sort of matters that I, my lady, had in mind.
Yes.
And I will address it. But before I get there, can I address the question whether criminal injuries compensation is the means by which that support is provided? And the way that it's been approached by Strasbourg is to answer that question in the negative. And of course, we say that Stewart, which the court was taking to this morning, provides powerful support for the proposition that it would be a significant departure from Strasbourg jurisprudence to treat criminal injuries compensation as falling within the ambit of Article 4. The court will recall it's the case in which the Strasbourg court held that the criminal injuries compensation scheme did not fall within the ambit of Article 3 for the purposes of Article 14. And it's for that reason that I drew the court's attention to that passage in Siliadin, which described the positive obligation under Article 4 as operating in the same way as that under Article 3. Can I ask the court to turn back to Stewart? It's 855, please. And you were taken to the passage roughly in the middle of the page. The court recalls that the obligation on the parties under Article 1 to secure the rights and freedoms defined in the Convention, taken together with Article 3 for our purposes, requires states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture. So that's the positive obligation identified. Just to flag up that this wasn't a new departure, the idea of a positive obligation. That paragraph starts with the words, the court recalls. And then in the following paragraph, we see deterrent sanctions were in existence. And right at the bottom of the paragraph, the court found, this is the last three lines, the state's positive obligation under Article 3 cannot be interpreted as requiring a state to provide compensation to the victims of ill treatment administered by private individuals. Now, of course, the appellants in this case don't need to show the violation of a substantive right, so that passage is not enough on its own. But as we turn over to 836, and it's the second to last substantive paragraph, the scope of the positive obligation.
I'm sorry, which page was it?
I'm so sorry, 856, it's the following page. Penultimate substantive paragraph of the judgment. The scope of the positive obligation under Article 3 does not extend to the payment by the state of compensation for injuries caused by the criminal acts of private persons. Follows the fact about which the applicant complains, namely the denial of compensation, does not fall within the scope of Article 3, and that Article 14 is not applicable. As we note in our case, Stewart was decided at a time when it was well recognised that Article 14 comes into play whenever the subject matter of the disadvantage constitutes one of the modalities of the exercise of a right guaranteed. And I'm deliberately quoting from Petrovich, because Petrovich was decided before this case. So the court in Stewart can't be said to have been ignorant of the concept that Article 14 comes into play where the disadvantage is a modality of the exercise of a right. And Petrovich itself refers to the modality principle. I'm so sorry, my Lord. Lord Stevens had a question.
So I didn't understand that in Stewart there was a compensation scheme, and the modality principle comes into effect when there is a compensation scheme. That's the first question, and the second is, I didn't understand also that in Article 3 there's an equivalent of ECAT, and that is an international agreement recommending that there be some form of compensation.
Take those in turn. So firstly, that there was a scheme in this case. The one can see from page 854 in the section of the facts. This was a complaint about the Criminal Injuries Compensation Scheme 1996. That's 2 paragraphs above the heading complaints. So rather like this case, that was a complaint about exclusion from the scheme rather than the absence of a scheme altogether. It was a complaint about exclusion under what was known as the same roof rule, an exclusionary rule which existed until 1979, or at least in relation to claims arising from the period before then, but which was only brought to an end following the Court of Appeal's decision in JT a year or two ago. As to the equivalent of ECAT, I'm sure my Lord's right. There's no direct analogy to be drawn in that regard. That's not the basis upon which we rely on Stewart. The question which Stewart assists with, the proposition of law which we say it assists with, is whether criminal injuries compensation, or rather state compensation for wrongs caused by individuals, falls within the ambit of whether it's Article 3 or 4, taking into account the need to fulfill positive obligations. And that's why we say it's significant that Stewart was decided at a time when it was, first of all, recognised that the article would give rise to positive obligations, and secondly, that Article 14 would come into play in the context of disadvantage in one of the modalities of the exercise of the right. And I'm very grateful to my learned junior who's electronically passed me a note drawing my attention to the Convention on Compensation for Violent Crimes, which of course is relevant to the the issue in Stewart. I'm going to come on to address the court on that issue, in particular in relation to the question of criminal convictions. But it's fair to say that there will have been international norms which would have been relevant in the context of Stewart. I'm grateful for that. If the court in Stewart had concluded that compensation was even arguably a modality of the exercise of Article 3 rights, we submit it would not have declared the application inadmissible. Now, the appellants identified an authority yesterday, MC in Bulgaria, and we understand that to be relied on as being the first time it is said that the Strasbourg court identified a positive obligation to conduct an effective investigation into allegations of ill treatment by private persons. And that doesn't seem to us to be right. The decision, if the court has it to hand, I'm not sure in what format it's with the court.
We have it in a separate file, Mr. Collins.
I'm grateful. So I am looking at page 486 of the judgment, which is page 28 if you have it as an electronic PDF. One can see the general approach identified at paragraphs 148 and 149, and one can see straight away that 149, what the court is doing is not setting out some new principle, but reiterating that the obligation requires states to take measures designed to ensure individuals are not subjected to ill treatment. So the positive obligation is identified from the outset. There's a footnote there, footnote 31 at the end of the paragraph, which cites earlier cases, one of which is A and the United Kingdom, which is a case about the protection for children who were subjected to corporal punishment in the context of the reasonable chastisement defence. That's a case, again, which predates Stewart and which confirms positive obligations in relation to deterrence and punishment. And we've referred in our case also to the case of Asanov and Bulgaria, which provides for a positive obligation in relation to investigation, albeit in the context of state harm rather than individual harm. Now, of course, the detail of the content of these positive obligations has been worked out over time. But there can be no doubt that at the time of Stewart, it was well recognised that there were positive obligations on the state, and it was found that in that context, those obligations did not extend to the payment of state compensation. Referring to other subsequent cases about investigation, don't really assist with that. So we say that Stewart's a case directly concerned with the question whether the content of the criminal injuries compensation scheme fell within the ambit of Article 3, and that there's no material difference when we look at Article 4 in terms of the fundamental character of the article and the positive obligations it gives rise to. And we say that Stewart is an important indication of the Strasbourg approach to the present case. And we note that the appellants have not been able to point to any authority decided before or since which says something different. And we say in reality that accords with the realities of the situation, because the scheme is not in reality a means or modality of discharging the state's Article 4 obligations. It's plainly not relevant to deterrence or prevention. That we respectfully suggest is obvious. We don't think it's controversial, but the court said it in August, page 2560, if authority is required. It's not relevant to punishment or prosecution either. It can only be relevant to protection in the sense of providing support, as my Lady Arden's identified, but it's not in reality a means of supporting victims of trafficking. It's a means of compensating individuals who sustained injury as a direct result of a crime of violence. Some of those people may happen to be victims of trafficking, and the scheme recognises that. But the scheme isn't how those people get the support they need as a result of or in the context of their being victims of trafficking. That support comes from a range of mechanisms which are set out in the evidence which was before the court below. Can I ask the court to turn up part 2 of the appendix? At page 38 is a witness statement of Joanne Savage of the Ministry of Justice. That was filed at first instance in this case. And at page 43, paragraphs 20 onwards, the court can see a short description of some of the support which is provided. Can I ask the court to read paragraphs 20 through to 24? I'm sorry, the reproduction is not great on the second page. If you need help with that, please come back to me. Can I check if my lords and my lady have been able to read those paragraphs?
Yes.
I'm grateful. Those mechanisms we would suggest are directed at the protection of victims of trafficking, whereas compensation under the scheme is something different. It's a recognition, as I submitted at the outset, of a sense of public sympathy for the pain and suffering of the victim, specifically in cases of injury sustained as a direct result of a crime of violence, which may or may not be the circumstances that we're talking about in this context. On that basis, we say that the connection between the scheme and Article 4 is tenuous at best. If there is a connection, it's not a meaningful connection, it's not a sufficient connection to bring this case within the ambit of the article. We say the Court of Appeal was right in its judgment in this case to indicate that it had a strong inclination that the appellants are unable to establish that the terms of access to the scheme fall within the ambit of Article 4. You will note that's paragraph 66. The appellants have characterised the Court of Appeal as having found for them on this issue, and in fact the reverse was almost but not quite true. The court decided in the end that it would proceed on the basis that there was at least a possibility that the threshold might be met so as to be able to make findings on the other issues. And this point wasn't argued at first instance before Mr. Justice Wilkie at all. We went Article 4 and 14 were not argued at first instance. We invite this court to hold that the Court of Appeal's inclination was right and that the subject matter of the appeal does not fall within the ambit of Article 4. That leads me on to the question of status Now, the appellant's case at first instance was that Article 14 was engaged by virtue of their status as persons who have received a custodial sentence or a community order. On appeal to the Court of Appeal, the same approach was taken. And on each occasion, the courts accepted that submission and found that the appellants did have the necessary other status on that basis. The grounds of appeal to this court were the same, looking at paragraph 8 of the Notice of Appeal on page 33, and not all that different in the Statement of Facts and Issues on page 55. But it appears that, in fact, there are two bases relied upon. First of all, the status as a victim of trafficking. Secondly, as my learned friend put it, those caught by paragraph 3, that being paragraph 3 of Annex D to the scheme. And I'm going to start by addressing the status, which has been the status throughout these proceedings in the Court of Appeal and the Administrative Court, a person with an unspent conviction of a relevant kind, or a person caught by paragraph 3. And the basis upon which Mr. Justice Wilkie and the Court of Appeal both found for the appellants was essentially on the basis that the decision of the European Court in Clifton, UK, rather inevitably led to that conclusion. And we invite this court to take a different approach. The best place to start is perhaps with Lady Black's summary at paragraph 56 of Stott. That's 2413. Back in the combined bundle. Lady Black undertook, as I suspect the court is familiar with, a review of all of the important authorities, including Clift, and said that I think it can be said, although acknowledging the danger of oversimplification, that prior to Clifton, UK, the House of Lords had adopted the following position, and she identifies a number of paragraphs there. 4 and 6 are the ones that I'll be focusing on. So 4, question whether the personal characteristic could be defined by the differential treatment of which the person complained, sometimes referred to as the independent existence criterion. Does the status have an existence independent of the measure which is complained of? And 6 over the page, question whether the real reason for the treatment is what someone has done rather than who or what they are. So first of all, the question, can the personal characteristic be defined by the treatment of which complaint is made? We invite this court to conclude that if it can't, because if it could, there'd be no need for the qualifying words of Article 14 at all. Lady Hale in Stott explains that. Paragraph 210, page 2456. Can I ask the court to read 210, please? We respectfully suggest that that approach is right. It's illustrated rather neatly at 211, the next paragraph, by analogy with the United Nations Convention relating to the status of refugees. One can see the explanation right at the last line of the page. Particular social group in that convention must exist independently of the persecution to which the group is subject. The group was not defined solely by the persecution it feared. And then at paragraph 212, Lady Hale goes on to explain that the group in Clift is not in fact defined by the discrimination in that case. We respectfully adopt that analysis. It leads me on to the case of Doherty, which my Lord Lloyd-Jones touched on this morning. That starts at page 2130, the case which turned on the timing of a sentence in effect. The relevant passage is at 2155. So sorry, it's the wrong place to start. What I'll do, if I may, with one eye on the clock, ask the court, perhaps in due course, to read paragraph 53, but it's a long paragraph and I don't propose to take time to look at it now. But then to go on to the section on discrimination on 2155, which is starts at paragraph 63. If I can ask the court to read paragraph 63, please. My lord, my lady, I'm going to slightly cheat in my analysis of this passage of the judgment by taking your lordship straight to the analysis of Lord Justice Lewison of it in the case of Simawi, and I'm not going to seek to improve on that. That starts at page 2349. There's a heading above paragraph 27 on 2349, discrimination on the ground of other status. And his lordship first of all identifies that other status, this paragraph 28, has some limits. Otherwise, the list of prohibited grounds would be superfluous, but where the limits are is more elusive. There's then a quotation, paragraph 29, from Lords Bingham and Hope in Clift in the House of Lords, where Lord Hope said, and this is the second quote over the page, that the grounds exist independently of the treatment of which complaint is made. There's then a reference to RJM at paragraph 30. After that, and I won't take the court through all of this for reasons of time, there's a review of what Lady Black said in Stott, paragraphs 31, 2, 3, and 4. And at 35, the Court of Appeal notes that it's clear Lady Black's discussion of the independent existence condition and her rather tentative conclusions about it were obiter. Lord Hodge agreed Mr. Stott had the required status, but he didn't discuss the independent existence condition or endorse Lady Black's discussion of it. Lady Hale was more supportive of the independent existence condition, and there's a quote from paragraph 10. which I've taken your lordships to. And paragraph 37 is an excerpt from what Lord Mance had to say about the importance of status as an independent question. And then down the bottom of the page at page 41, after, I should mention Lord Carnwath's dissent at paragraph 40, Court of Appeal says this: the observations of all the justices in Stott were obiter, because with the exception of Lord Carnwath, they all decided Mr. Stott satisfied the independent existence condition. As Lady Black said, the independent existence condition lives on in Doherty. That was a decision of the Supreme Court in which Clifton UK was considered. The decision that Mr. Doherty did not have other status because the suggested status is defined entirely by the alleged discrimination was part of the ratio. Stott does not depart from Doherty in that respect. It therefore bound the Court of Appeal, and we say it is good law, and we invite this court to take the same approach in this case. One other example, which we say may be of some assistance, I won't take the court to it, but I'll give you the reference. It's the case of HC, page 1738. It's the case where one of the statuses relied on was that of being a Zambrano carer. You'll note it's paragraph 31, when this court concluded that Zambrano's status was simply a creation of European law. Any difference in treatment of a Zambrano carer did no more than reflect the law by which the status was created. And that's exactly what we say is the case here. The law by which the status is created is the secondary legislation, which is the scheme, and in particular paragraph 3 of Annex D. And we note the formulation of my learned friend this morning. The status that she relied on was those caught by paragraph 3. That's an express submission that the status is defined by the legal provision. And there's nothing about that group which is defined other than by the paragraph itself. It started out, the status relied on, as those with unspent convictions resulting in a custodial or community sentence or a relevant sentence. So what's happening here is that the paragraph 3 collects together a number of different kinds of sentence. It then limits itself by reference to the 1974 Act. But what binds those categories together? Nothing other than paragraph 3 itself. And my learned friend submitted that the sentences are all defined by the Rehabilitation of Offenders Act, and we say that that's wrong. If the Act defines how those sentences should be treated for the purposes of when they will be spent, but it doesn't define the offences. And indeed, it takes a different approach to different kinds of offence, depending on, apart from anything else, length of sentence. If the status is otherwise defined at all, we say it isn't, but if I'm wrong about that, it's defined by the seriousness of what the individual has done. And that's because sentence derives not from the 1974 Act, but by considering culpability and harm together with any aggravating or mitigating factors. And when one then adds in the question of whether the sentence is spent, that depends on a temporal perspective, in effect, of seriousness. So first of all, the greater the seriousness, the longer the rehabilitation period. But secondly, we look at it at the present date, because an offence a longer time ago is more likely to be spent and is treated less seriously than a more recent offence. So this is a good example, we respectfully submit, of a case which is not about a personal characteristic of an individual. It's about what they have done. And in that, on that basis, it's a much more of a case like Gerger than it is a case like Clift. And indeed, it may be helpful for me to refer back to Scott one last time. Page 2461, this is Lord Mance. Paragraph 230, which is towards the bottom of 2461. He considered Gerger, and he said that the difference in that case was based on the differing gravity of the offence rather than on any status. And he says in terms, a mere difference in the sentence imposed cannot of itself amount to a difference in status. And then at paragraph 231, that a mere difference in treatment doesn't by itself constitute a difference in status is a proposition difficult to fault in the light of Gerger. And he goes on then to deal, and I don't ask the court to, in fact, to look at this now. This is coming back to the independent existence criterion. But how do we, if assuming Lord Mance is right, as I do, to say that a mere difference in sentence imposed cannot of itself amount to a difference in status, how do we explain Clift? Well, we start from the premise that being a convicted prisoner is a status, and we take that from Shelley. That's page 3172. And I will take the court to it because there's no paragraph numbers. It'll be easier to find if I deal with it orally. It's right in the middle of the page. Under the court's assessment, it's the second paragraph, which begins with the words, insofar as the government argued. And the court observes 3 lines down that being a convicted prisoner may be regarded as placing the individual as in a distinct legal situation, which, even though it may be imposed involuntarily and generally for a temporary period, is inextricably bound up with the individual's personal circumstances and existence, as may be said variously of those born out of wedlock or married. So that's an important difference between simply looking at sentence and looking at the consequences of the sentence in terms of imprisonment, and that is important. We can see from Clifton UK itself, page 2603, paragraph 62 is the first complete paragraph on the page, where the court says this: the court has frequently emphasised the fundamental importance of the guarantees contained in Article 5 for securing the right of individuals in a democracy to be free from arbitrary detention at the hands of the authorities. Where an early release scheme applies differently to prisoners depending on the length of their sentences, there is a risk that unless the difference in treatment is objectively justified, it will run counter to the very purpose of Article 5, namely to protect the individual from arbitrary detention. And we say that's important.
What do you think is the significance of that, Mr. Collins?
Because we say that the approach to the question of status is inevitably informed in Clifton UK by the fact that this is in the context of the safeguards under Article 5, and that these are serving prisoners whose release is being considered. And their status as prisoners informs the question of whether they have a status as a prisoner serving a particular kind of sentence. That was relevant in support of that proposition. I note that Lady Black in Stott relied on it. Rather than leap around in the bundle, I'll simply give the reference if I may. It's paragraph 81, page 2421, where she bore in mind the warning of the Strasbourg court that there's a need for careful scrutiny of differential early release schemes lest they run counter to the purpose of Article 5. So we say there's a difference in quality between a status as serving a particular kind of sentence in prison and simply looking at the nature of a sentence which has been handed down in the past in terms of its effect for the purposes that we're looking at. My Lord Stevens has a question.
Does that mean then that somebody convicted as A and B have been convicted and sentenced to prison, as A and B were sentenced to prison, had a status when they were in prison, but lost that status whenever they were removed from prison? So that if they had been attacked whilst in prison by some other criminal, they would have the status, but otherwise they wouldn't.
They would have the status of being a convicted prisoner, and if the scheme had a provision in it which precluded applications by individuals who were serving prisoners at the time when they sustained the injury, for example, then leaving aside all of the other parts of the analysis, the other status part of the analysis would be fulfilled. Shelley tells us that, apart from anything else. The fact that they have in the past served a sentence of imprisonment doesn't confer a status on them now, is the submission, which we say follows on from Clift and Lady Black's approach to it in Stott. To summarise that, we'd say that having an unspent conviction, which has resulted in a particular kind of sentence, for our purposes a custodial sentence, can't be another status, even allowing for, we accept of course that a liberal interpretation, a generous interpretation is what the guidance that we have from the authorities, but one can't stretch it that far. I need to go on to deal with the new argument that there's a status in being a victim of trafficking. And that argument necessarily results, we would suggest, in the approach that being a victim of a particular offence or a particular kind of offence is enough to amount to an other status. But the authorities are clear that just as what someone has done is not a status, nor is what has been done to them. And that's said in terms in RJM, paragraph 45. What we'd say about this is that the issue is not whether victims of trafficking have access to the scheme. We know that they do. The question is whether different rules and more favourable rules should apply to them because they are victims of trafficking. But if being a victim of a particular kind of crime is a status, then almost any aspect of the scheme might have to be considered in case additional benefits were required for victims of a particular kind of crime. To focus on the part of the scheme that we're concerned with here, Annex D and previous convictions, sadly, it's fair to say it's not unusual that those who commit offences do so in circumstances where they are vulnerable. It's not at all unusual that they do so because of their particular vulnerabilities, and not unusual that they do so because of exploitation. That sad set of circumstances is not unique to victims of trafficking. The Court of Appeal said something similar in their judgment. So, my learned friend said this morning that her submission wasn't that it's simply the fact that one can identify the nature of the offence and that leads to the status of the victim of that offence, and that concession we suggested is rightly made. But to go on to say that it's the particular vulnerability of these individuals which gives them status where victims of other crimes might not, simply ignores the reality that victims of crime all have different vulnerabilities, and those who commit offences may well have different vulnerabilities. But what one can't derive from that, we would respectfully suggest, is a status for the purposes of Article 14. If you're against me on all of that, where are we in terms of Lord Walker's concentric circles? We are right on the outside in our respectful submission. The if you're against me, in particular in relation to the previous convictions, in relation to paragraph 3, we must be as far to the outside as it's possible to get. That really is a group which is constructed in such a way that it's impossible to identify the core values of Article 14. But we say that if we're wrong on the question of victim of trafficking being a status as well, we are nearer the outside than the centre, if I can put it that way, given the sorts of vulnerabilities that we're talking about are not confined to any particular group. I go on to deal with the question of difference in treatment. Now, of course, there's a difference in treatment between those with unspent convictions and those without, and I go on to deal with justification in a moment to deal with that. As to the fact that the appellants are victims of trafficking, now, of course, it's right that paragraph 26 and Annex D operate in the same way for victims of trafficking and other applicants, and this is put on a flimenos basis. The appellant's case is that they are in a sufficiently different position from other victims of crimes of violence that it's necessary to justify treating them the same. The difference that they rely on boils down in essence to the proposition that the convictions which exclude them from the scheme may not be safe. And I'll deal with that when I address justification. But really that's what it comes down to, saying that they've not, the risk is that they've not been adequately protected by the non-punishment regime. We make 2 points about different treatment in this regard. So first of all, by way of example, there are some features of the scheme which ensure that victims of trafficking are not disadvantaged by, for example, matters to do with immigration and residence arising from their trafficking, but those features aren't an issue in this appeal. More fundamentally, we say that their status as victims of trafficking really is irrelevant to the operation of Annex D in their case. And so far as these appellants are concerned, that's rather important because their convictions are unrelated to, they can't be said to be caused by their trafficking. As the Court of Appeal put it rightly, their convictions have no evidential nexus with their trafficking. It follows that the theoretical difficulties which the appellants and the intervener say might arise for some victims of trafficking convicted of offences which are as a result of their trafficking, those difficulties don't apply to these appellants at all. So in order to succeed, my lady, yes.
Could I just ask a question which leads on from what you've just said? If the position is that there is no evidential link between the offences with which we're concerned and the trafficking, and if there is no pleading of any kind as to what might be the reasonable ground for the exercise of discretion in their favour as victims of trafficking, do you think, do you wish to submit that they are not in fact victims at all for the purposes of Section 7 of the Human Rights Act? To do that, they have to show that they're victims under Article 34 of the Convention. And in that case, you can't take a case about something which is academic to you in most situations. You have to show some reasonable basis for saying you are a victim of that violation that you wish to establish.
Well, my lady, the way we put it is this, that they can't succeed in this appeal and they couldn't succeed in their claim because they can't show that they should be treated more favourably than those who aren't victims of trafficking, because they're victims of trafficking. When they are relying on matters, they'd have to rely only on matters which are unrelated to trafficking. So the claim inevitably fails in those circumstances. We've not sought to put it in terms of their not being victims, and we've not taken a point on standing or anything of that sort. But what we say is that there is a substantive difficulty with the appellant succeeding in the absence of showing what amounts to less favourable treatment, if I can put it that way. There's no disadvantage there. And when I come on to deal with relief right at the end, I'll say it certainly isn't appropriate to grant a remedy if you're against me on that and the other parts of the appeal. I don't know if that deals with it sufficiently for my lady.
Well, just for the purposes of future cases, is there a point here that ought to be looked at about victim status?
It's fair to say I asked myself the same question over lunch in light of my lady's question, and I can't honestly say I've got an answer that I'd be comfortable giving to the court without instructions this afternoon. I'm sorry that's chickening out, but I think it's only right without instructions.
Absolutely.
Mr. Collins, you were in the middle of making a submission, your second submission, which I'd noted was that the convictions of these appellants are unrelated to trafficking. So the theoretical difficulties for some victims of trafficking do not apply to these appellants. And I think you were then going to draw a consequence from that.
I was, and I'd sought to express it in my response to Lady Arden's question, which is that they can't succeed as a consequence of that. And even if I'm wrong about that, they shouldn't be granted relief.
Thank you.
My Lord Stevens has a question.
I mean, there are two ways of addressing what is question 3 in DA and DS, and one is the theomonymous approach, which is the one that you're looking at the moment, and that is that people who are different shouldn't be treated the same, and you're saying that this group is not different, as I understand it. They are exactly the same as other victims of crime. And there is no reason for not treating them in the same way. And if that is correct, Lord Wilson in DA and DS said that the way of formulating the claim can be turned inside out. It can be turned the other way around, and that is, you can look at it that from the point of view of an analogous situation. The people are the same, should be treated the same. But no matter whether you turn it inside out or whether you don't, it should come up with the same result. And my difficulty at the moment with the analogous situation is I cannot see how you can say that somebody who is a convicted criminal is an analogous situation to somebody who hasn't got a conviction. So that if you have an applicant for compensation who has committed crimes in the past, I don't see that that is analogous to somebody who hasn't got crimes in the past. And so, I mean, my thoughts so far, and just for discussion, is that no matter which way you look at, whether you turn it inside out or not, it faces difficulties at the third question in DA and DS.
Well, we respectfully agree that in both directions, the appellant's case doesn't work. One way one might put it, one might think about it, is to say, to ask the question why a victim of trafficking who is a victim of a crime of violence should be in a different position to any other victim of a crime of violence, so as to give rise to the need to justify treating them in the same way. And we have a difficulty with that analysis as well. So, my lord, it may be that I can bring this out in the course of my submissions on justification, which is the next topic that I'm going to need to address. But we respectfully agree that there is a real difficulty with the appellant's analysis. I turn then to justification, and there are again some preliminary points I'd seek to make. Firstly, in terms of the approach for the court, question on the appeal is, of course, whether the decision appealed is wrong. requires the appellants not simply to persuade you to reach a different conclusion on justification, but rather to identify a flaw in the reasoning, a gap in the logic, an error of approach, and we say that there is none, of course. Secondly, it's not in dispute that the applicable test is whether the difference in treatment is manifestly without reasonable foundation. And because it's not in dispute, I'll take it briefly, but I'm not going to skip straight over it in light of the submissions that my learned friend has briefly made about the approach to proportionality, and also in light of what may be happening with SC. In summary, we say that the Court of Appeal was right to conclude at paragraph 92 that this is a case which cries out for judicial restraint, to borrow Lord Justice Gross's words. Why is that? Well, firstly, this is a policy decision in the field of socio-economic policy, and specifically in relation to welfare benefits. What I'll do is just give the court the headlines and the paragraphs of our case to save time. So that's paragraphs 81 to 87, where we cite Steck and Humphreys and RJM. Secondly, the terms of the scheme have been considered by both the executive and by Parliament. Paragraphs 88 to 91 of our case, SG, Bank Mellat and Countryside Alliance. Thirdly, legislation cannot be framed to address particular cases, but must lay down general rules, and it's for Parliament to decide where those lines are to be drawn. Our case paragraphs 92 to 94, Animal Defenders and Matheson and Tiger. And then fourthly, if the appellants have overcome the status threshold, and we are right that they're in the outer ring of Lord Walker's concentric circles, that necessarily makes it easier for a difference in treatment to be justified. In summary, we say this is a case which concerns political decisions about the allocation of scarce public resources, approved by Parliament, in a case which is not about suspect grounds, and in those circumstances, the widest margin of judgment is available. And I may go a little further than my learned friend and rather anticipate whatever may be said in SC. We say that those features mean that essentially the same approach is taken to this case whether one attaches the ghastly letters MWRF to it or not. And there are a number of Court of Appeal authorities which have looked at that we cite in our case, in particular Drexler and Joint Council of Welfare Immigrants, which both of which identify that whichever approach one takes, and Lord Justice Leggett's approach is perhaps a little bit similar to this, where one has all those features, a political case, a benefits case, approval by Parliament, not about suspect grounds, whether one labels it manifestly without reasonable foundation or not, essentially the same approach is appropriate, which is for the court to tread with the greatest care before concluding that a decision is unlawful. And then the final introductory point that I wanted to make is that all of the submissions in the appellant's written case address the question of justifying discrimination against victims of trafficking. None of them appear to address the question of the justification of discrimination against those with unspent relevant convictions, which is what this case was all about until very recently. But one can't ignore the fact that this is a measure about removing entitlement to compensation for those with unspent relevant convictions. That is the legitimate aim, which is agreed. Not been suggested either that it's not the aim or that it's not legitimate. The aim is paragraph 207 of the 2012 consultation document, which is in Appendix 2. It's page 109, 109. The court, I think, in fact, was taken to this morning. It's the passage which says tougher rules are warranted. The scheme is a taxpayer-funded expression of public sympathy. It is reasonable there should be strict criteria around who is deemed blameless for the purposes of determining who should receive a share of its limited funds. In principle, awards should only be made to those who have themselves obeyed the law and not cost society money through their offending behaviour. So the aim is to focus compensation on blameless victims. That is set in the context of the broader aims of the scheme as a whole, which one can see at page 100. I won't go through all of it, but the court can see paragraph 172 identifies the principles taken into account when considering reform of the scheme. Not only is the aim a legitimate one, it's indeed consistent with internationally accepted norms. And I indicated to the court earlier that I would take you to this. It's the European Convention on the Compensation of Victims of Violent Crimes. Can we look, please, at page 988 in the combined bundle? Article 8, you were taken to 8.1, compensation may be reduced or refused on account of the victim's or the applicant's conduct before, during or after the crime or in relation to the injury or death. You weren't taken to 8.3, which is also important. 8.3 says compensation may also be reduced or refused if an award or a full award would be contrary to a sense of justice or to public policy or ordre public. And there's an explanation for that in the explanatory notes, which is relevant. Page 999, please. Now, the note to Article 8, which provides at paragraph 33 that Article 8 allows compensation to be reduced or withheld where the victim is at fault. There's a reference to the first paragraph, Article 8, talking about where the victim triggers the crime. But that's not really what we're talking about in these circumstances. But if the court goes over to 1036C, compensation repugnant to the sense of justice or contrary to public policy, states which introduce compensation schemes usually want to retain some discretion in awarding compensation and to be able to refuse it in certain cases where it's clear that a gesture of solidarity would be contrary to public feeling or interests, or would be contrary to the basic principles of the legislation of the state concerned. This being so, a known criminal who was the victim of a crime of violence could be refused compensation even if the crime in question was unrelated to his criminal activities. So there is no doubt that there is an international consensus that it is reasonable and may be appropriate to refuse compensation to those who have committed crimes themselves. Now, the means chosen to achieve the legitimate aim is the exclusion from compensation of those with unspent convictions for the most serious offences, that is, those resulting in custodial or community sentences. And the operation of Annex D is, as the courts below rightly noted, nuanced. It's very far from a blanket ban. So those with the most serious convictions are excluded altogether by paragraph 3. Those with more minor convictions are excluded but with a discretion in the presence of exceptional reasons, paragraph 4. Those with the most minor convictions are included. And factored into that is the fact that when a court sentences, it will take into account seriousness. In considering seriousness, the court will consider the offender's culpability, and any harm which the offence caused or was intended to cause or might foreseeably have caused. And community and custodial sentences may only be passed where the offence is so serious that a lesser sanction would be inappropriate. So those gradations factor in all of those matters, and then the date of the offence, of course, is further factored in by reference to the question of when the conviction becomes spent. And that, of course, takes into account both the gravity of the offence and the time which has passed. And all of that was properly recognised at first instance and by the Court of Appeal. And if we relate that to these appellants, given that it's a legitimate aim to focus compensation on those who are blameless, that is, those who have not committed criminal offences, given that these appellants are not blameless because they did commit offences before they were trafficked of sufficient seriousness to result in custody, their exclusion from the scheme cannot be said to be manifestly without reasonable foundation. In case of doubt, the exclusion could not possibly be characterised as indiscriminate, to borrow the language of Hurst, which was highlighted at one point. I'm not sure the extent to which it's still relied on. The height of the appellant's case appears to be that when the scheme was reformed in 2012, a discretion should have been retained in exceptional circumstances in the cases of applicants with criminal convictions. And having heard learned friend submissions today, that may be restricted to those victims of trafficking with criminal convictions. In either event, the basis for that case appears to rely wholly on the premise that victims of trafficking may have unspent convictions because they have been trafficked as a result of failures in the non-punishment regime. And leaving aside for the purposes of this submission the fact this isn't the position of these appellants anyway, it doesn't assist. And we say that is for these reasons. Firstly, a victim of trafficking can avail themselves of the non-punishment regime under Section 45 of the Modern Slavery Act. That provides a defence for victims of trafficking in addition to the common law defence of duress, if that is applicable. The court has a further power to stay a prosecution or to quash a conviction if the individual is not identified as a victim of trafficking until after conviction. And that is, we say, a lawful and proper regime. But the appellant's case necessarily relies on showing the regime itself is in some way flawed and doesn't work. And there's no evidence of that. And what I propose to do to make good this submission is to deal with the propositions advanced by the appellants in their case. It's on page 97. It's within paragraph 128 of the appellant's case. And the appellants say that the assertion that if a victim of trafficking is not able to avail herself of these protections, it's because she's not blameless. It said that that assertion is wrong for a number of reasons. I just want to address them. The first, number one, is that the provisions depend in the first instance on the correct identification of the victim of trafficking. And of course that's right. Any system depends on its being operated properly. There's no evidence before the court that this gives rise to systematic problems, but in any event, it wasn't an issue in the present case. Secondly, the point is made that the discretion not to bring a prosecution may not be able to be exercised if identification as a victim of trafficking doesn't occur until later and perhaps after conviction. Well, if the individual is identified as a victim of trafficking after conviction, the conviction can be quashed. And if that takes place, the individual is able to argue that time should be extended for an application for compensation under paragraphs 89 or 109. We make this observation: if a victim of trafficking has been made aware of the scheme, that is most likely because they've been identified as at least a potential victim of trafficking, either by the national referral mechanism or in some other way, which means that they've got access to some legal advice. That makes them more likely to have assistance with an application and to make an application under paragraph 14 of the scheme, which the court may recall. Paragraph 14 allows a decision to be deferred while an individual awaits a determination as to whether they're a victim of trafficking or not. But the short point is, if identification occurs late, that can be dealt with by quashing a conviction. That answers, we say, also point 3 on page 97. Point 4 is that the statutory defence might be excluded because the offence falls within Schedule 4, and Schedule 4 contains some offences which Parliament has concluded are so serious that they should be excluded from the enhanced protection of Section 45. That, of course, is a matter of primary legislation. It recognises that there may be no circumstances which can justify the commission of some crimes. Having said that, the defence of duress may be available in some circumstances. Even if convicted, the individual will be entitled to rely on their circumstances in mitigation. If Parliament has concluded that an offence is so serious that there should be no enhanced protection arising from trafficking, we say it can't be right to say that the perpetrator must be entitled to enhanced access to the scheme, or put another way, that it would manifestly be without reasonable foundation to take the opposite approach. Point 5 talks about victims of trafficking not being identified and the need for adequate funding to obtain fresh evidence, to get permission to appeal, and so on and so forth. And again, of course, that's true. No system of criminal justice is perfect. All criminal cases depend on legal advice and representation and evidence, not just those involving victims of trafficking. What's an appropriate course in relation to the scheme? Well, any scheme has to proceed on the basis that a conviction, and indeed an acquittal, can be relied on unless and until it's overturned. And then finally, at points 6 and 7 talk about different practices across different EU member states, and I take those two together. And we'd suggest that the principle of mutual trust provides the proper approach, which is namely to proceed on the basis that the legal systems of those states are capable of providing equivalent and effective protection of fundamental rights, including the Charter of Fundamental Rights, which provides specific safeguards, and the Trafficking Directive as well. There is some harmonisation of sentencing practice, of course, in the EU. And then finally, Annex D contains at paragraph 6 provision excluding certain overseas convictions where they're for matters which would not be crimes anywhere in the UK. At the heart of all of the appellants' submissions along these lines is an assertion that there's a risk the system may not work as it should. But we respectfully submit it's not enough to assert that a proper regime may sometimes fail. The relevant question is whether the regime is capable of being operated in a manner consistent with the appellant's rights. And in this case, we say it plainly is. Indeed, the appellants positively assert that failures will be few and far between. Paragraph 143 of the appellant's case says that given the non-punishment provisions, it's inconceivable that the number of victims of trafficking caught by paragraph 3 will be substantial in number. So even the appellants acknowledge that failures of the system will be rare in this context. We say, therefore, that a policy which relies on the criminal justice system to identify those who are properly convicted cannot be said to be manifestly without reasonable foundation, and the courts below were right so to find. We respectfully suggest that all of the complaints made by the appellants and the intervener to the effect that victims of trafficking are likely to be excluded by Annex D because they won't benefit from the non-punishment regime are answered if one takes that approach. And of course, none of those issues apply to these appellants in any event. My lord, my lady, we've set out some submissions in writing about the consultation. I don't propose to go over those orally. There's nothing to respond to already from my learned friend apart from anything else. The court can see what we've had to say about it. We say the Court of Appeal took the right approach to it. Put shortly, there was a very detailed consultation process. We are in very different territory than Brewster, in which no real consideration was given to the consequences of the regulations at all. Considerable and detailed thought was given as to whether a discretion should be retained. It can't be said that it was manifestly without reasonable foundation to reach the conclusion that was reached. That just leaves me with the question of relief. Of course, this is a claim for judicial review brought under the Human Rights Act, which means, firstly, that relief is discretionary, and secondly, that a remedy should only be granted where it is just and appropriate. We were sent towards the end of the afternoon yesterday a new proposition as to what the appropriate remedy should be. I don't know whether, I know my learned friend is going to send it in writing.
We've not received it yet, Mr. Collins.
Very well. Well, I don't want to overcomplicate matters, but can I just say this? What we understand the proposition to be is that there should be a saving in paragraph 3 to this effect, that save in the case of a victim of trafficking to whom paragraph 4 below will apply. It may be helpful to have page 554 in front of you when I deal with this. So one can see paragraph 3 and 4. Paragraph 3 is the mandatory exclusion for certain sentences. Paragraph 4 allows for exceptional circumstances in the case of different offences. And the proposition is effectively that words should be read into paragraph 3 to move victims of trafficking into paragraph 4. Of course, that doesn't address the question of those whose status is simply to do with their convictions. But there we have it. Our first submission is that it would be wrong to grant a remedy on the basis of arguments which have nothing to do with circumstances of these appellants. I've already made submissions along those lines. Our second submission, which we make without prejudice to the first, is that it must be for Parliament and not the courts to rewrite the scheme. We've set this out, and I won't need to go over all of it, in our case, page 140, starting at paragraph 146. I won't ask the court to read all of that now, but that's where the argument begins. The next thing to say is that the appellant's formulation doesn't in any event work. It attempts to apply paragraph 4 to victims of trafficking, but the wording of paragraph 4 won't make any sense in the context of a victim of trafficking with a custodial or community sentence. It will become contradictory. What that demonstrates is that the scheme will need rewriting. It's not simply a matter of adding a few words here or taking a few words away there. We address that sort of approach in our case at the section that starts at paragraph 148 and runs through to the conclusion. And I don't propose to go over all of it orally. This is a matter for Parliament, or strictly speaking, for the executive with the approval of Parliament. The sort of rewriting which would be necessary in the present circumstances will not necessarily be straightforward. It may have unforeseen consequences, and there may not be only one way to deal with this. But conscious that I'm making the submission slightly in a vacuum because the court doesn't have the wording in front of you, and having indeed only seen the wording ourselves last night, would respectfully suggest that if the court is against us on the merits of the appeal and is minded to make an order along the lines of those indicated by the appellant, we'd simply ask the court to consider whether it's necessary to hear further submissions as to the detail of it. Perhaps I'll leave that there. The last point that I would make is to say that there's no realistic prospect whatsoever that these appellants would benefit from an exceptional circumstances discretion given their history of offending. In those circumstances, it would be wrong to grant a discretionary remedy in their favour. My lords, my lady, those are the submissions that I wanted to make, unless there's anything further that I can assist with. Lord Burrows.
Yes, just to follow up on the relief point, if I may, I think your indication is that the suggested interpretation by reading in additional works may be problematic. Would that, if we were against you on all the other matters, would that lead you to be saying, well, it should be a declaration of incompatibility?
No. As far as one could go, it seems to me, is to make some sort of a declaration indicating the way in which you were against me. But it would be possible for further secondary legislation to be made in a way which was not inconsistent with the convention. So, but we say the right way to go about that is for the matter to go back to Parliament and the executive for them to identify the correct formulation, rather than for the court to do the rewriting itself.
Mr. Collins, you mentioned, going back to justification for a moment, you mentioned that there was no evidence before the court. What, in relation to the operation of the scheme, what evidence was there precisely in relation to the operation of the scheme? Where do we find it?
In relation to which aspect of the operation of the scheme, my lord?
I understood the way in which it might have disadvantaged victims of trafficking.
There's no evidence about that at all in this sense. That this case was, as originally brought, leaving aside there were other parts of the case which were argued in relation to EU law and Article 17 of the directive, which weren't successful and have come to an end. This part of the case, the human rights part of the case, was not argued on the basis that there was discrimination against victims of trafficking. It was argued on the basis that there was discrimination against those with certain relevant unspent criminal convictions. So the evidence was directed at that issue. The only evidence that is available in relation to the circumstances of victims of trafficking, I've already taken the court to in terms of a Savage's statement, which was in Appendix Bundle 2 at page 38. There was a further statement which appears at page 737. But that focuses very much on the unspent convictions rule.
Thank you very much. Any further questions, Mr. Collins? Thank you very much. Ms. Kaufman.
My lords, my lady, can I start with Rantsev? So we're now going right back to Ambit. And,
right.
So Mr. Collins took you to Rantsev and made the point that the reference to the way in which the court will interpret the convention in light of international obligations was all made in the context of determining whether or not trafficking fell within the purview of Article 4. And that is indeed the case, that's where the analysis took place, but the nature of the analysis was an analysis of principle about the interpretation of the convention. And this is made abundantly clear by the later cases that I took you to this morning of Chowdhury and SM and Croatia, and we need to look no further than SM and Croatia, paragraph 295 on page 813, where the lie is given to the points that Mr. Collins was attempting to make, that nothing that was said about how in interpreting the convention one looks to other international instruments bore upon the positive obligations, because at 295, in answering the question of what definition of trafficking is to apply, the court at 6 lines from the bottom, and I took you to this earlier, specifically referred to the way in which in Chowdhury,
I do apologise. What's the page number again?
I'm so sorry. Page 813, paragraph 295. And if you will look at about 6 lines up from the bottom of 295, so here the court is trying to define trafficking as between the Palermo Protocol definition and ECAT. Is it national, international in relation to organised crime, or international in relation to any crime? And as we saw earlier, it decided that it was going to take the ECAT reference, and it did so. Secondly, it said, the court has already held that member states' positive obligations under Article 4 must be construed in light of the Council of Europe's Anti-Trafficking Convention. So that is a total and complete answer to the points raised in relation to Rantsev. Can I come on to then the case of H and the Secretary of State for the Home Department? You weren't taken to it, but for the court's note, that was a decision made before Chowdhury and before SM and Croatia. We agree with the point made by Mr. Collins that you do not read over directly the rights in ECAT, but I addressed that earlier, and I addressed specifically why Article 15.3 and 15.4 do fall to be read over. Next, Lady Arden raised the point that what is envisaged under Articles 15.3 and 15.4 is either a compensation fund for victims paid by the traffickers, or a fund by the state. And in my submission, that is not what is intended in Articles 15.3 and 15.4. The state is required by Article 15.3 to make provision for compensation to be paid by traffickers, but it must also, because traffickers will ordinarily not pay, make sure that there is alternative provision provided by the state. And that's clear from page 958, paragraph 198 of the explanatory note on ECAT. So that's page 958. Towards the bottom of the page is 198. And if the court would just read that quickly. And this is in part in answer to Lord Stevens as well. It is clearly envisaged the state will make provision. How it does it is up to it, but it will make some kind of provision. It could do it by taking money from the compensation schemes established in relation to criminal conduct, or some other way, but it shall do it. Can I then come on to... so all of that was addressing whether or not Article 5.4 is part of and incorporated into the positive obligations under Article 4. And then there is the positive modality way in which we also put the case. So assuming that the court is not with us and the court concludes that Article 4 does not impose any such obligation, then we're in positive modality territory. And we are dealing with a situation in which what the state has decided to do is for the benefit of trafficking victims, albeit not obliged to do it under the Convention and under Article 4, it has decided to provide for them to have access to its state compensation scheme where they are victims of crimes of violence or sexual offences. Now, that is plainly something, when one applies the very, very loose sense of in the ambit being linked to, that is plainly something that is for the benefit of victims of trafficking who fall within the purview of Article 4. It is plainly intended to compensate them for the injury that they suffered, that it is the state's duty to take steps to prevent and protect them from. There is in my submission no question whatsoever of the necessary linkage. And the very fact that an international instrument to which the United Kingdom is a signatory obliges states to do that demonstrates that linkage plainly in our submission. And if your lordships and my lady in your own time look at paragraph 55 of Smith and Lancashire, page 2380, to which Mr. Collins took you, you could not have a clearer case falling within the notion of ambit and linkage than a situation such as this. Stewart is a very odd decision. There is no consideration of Petrovich whatsoever, no consideration of the positive modality cases. So if we come to the wording of Stewart, if we can go to page 856, and under the citation of Article 14, if I can ask the court to read the paragraph immediately under that citation and then the following paragraph before it gets to it follows that these complaints are incompatible. And in doing so, notice how Petrovich does not figure whatsoever. So what they do, as one can see at the second paragraph, they find that as a matter of substantive law, there is no positive obligation to confer access to a compensation scheme or to provide a compensation scheme. And the third line from the bottom of that second paragraph, it follows from that fact that there is no substantive duty that about which the applicant complains, namely the denial of compensation, does not fall within the scope of Articles 3 and 8. It doesn't fall within it because there's no positive obligation. And that it also follows that Articles 13 and 14 are not therefore applicable. Well, it doesn't follow if you look at Petrovich, and they don't cite Petrovich. The other instrument that isn't cited is the Compensation Convention on Violent Crimes. There is no reference to that convention. And finally, I come back to where it is that in Chowdhury, the court derived the positive obligation, and that was in respect of the procedural obligation to investigate a criminal offence and subject it to prosecution, and we see from Chowdhury to then ensure that there is some kind of compensation framework provided either in those proceedings or by the state in respect of any wrongdoing done to the individual victim of trafficking. And I repeat that if your lordships and your ladyships have an opportunity to look at MC in Bulgaria, that is the first case where a duty to conduct an effective investigation was identified, as opposed to, under Article 3, as opposed to the duty to prescribe ill treatment in criminal law. So they took a step further and they said, you don't just create a system prescribing it, you don't just create a system for investigation, such as establishing a police force, you must also carry out an effective investigation, which will entail a prosecution at the end of that process if the evidence supports it and so forth. So I come back to the point, and I reiterate it, that Stewart is an early decision. It's a strange decision. It doesn't refer to a very, very important aspect of the Convention jurisprudence on positive modality, and the particular positive obligations simply had not been recognised, to which these duties attach. And I turn to status. The key status here is being a victim of trafficking. That is the status, and whilst I'm touching on it, can I just mention, in response to Lord Stephen's point, not being able to see that that is a status that is that there is anything analogous within the scheme, because individuals who have victims of trafficking who fall within paragraph 3 are necessarily victims of trafficking who have committed an offence, and therefore they are not analogous to victims of trafficking who haven't committed an offence. Well, that is right, but they are analogous to victims of trafficking or other victims of crime in paragraph 4, all of whom have also committed an offence. And it's the comparison between those two provisions that we are concerned with, not a comparison with individuals who've committed no offence. But being a victim of trafficking is, in my submission, unquestionably a status for the purposes of Article 14. The only answer Mr. Collins has to this is that this is something that is done to an individual. And as such, relying upon what Lord Newberger said in RJN, this can't possibly be a status. But as Lord Wilson pointed out in Matheson, even there, in that very same case, the status that was settled on was in fact something that was done to the individual. Moreover, in the face of Clift, in the face of Stott, it is impossible to contend that you cannot have a status by reason of what is done to you, because being a prisoner is something that is done to you. Being an extended sentence prisoner is something that is done to you. And Clift and the UK makes it abundantly clear in the paragraphs I cited and took your lordships and my lady to earlier, that there is no rule that you cannot be or have a relevant status because of something that is done to you. And I come back to the numerous ways in which victims of trafficking have a status by reason of the obligations that are owed to them as a class, both in international law, under Article 4, by reason of the establishment of the national referral mechanism, and all the assistance that Mr. Collins himself identified that they are provided with. So it's absolutely clearly a status. So the other way in which we put it, and we said that we don't need that. The most obvious status here is that they are a victim of trafficking and that they should be treated differently from other victims of crime who are also caught by paragraph 3. That's who they fall to be compared. And they should be treated like those in paragraph 4, with whom their cases are truly analogous. That is the nature of the case. But if we do have to come and characterise this in a different way, whereby we are comparing ourselves to other victims of trafficking who are within paragraph 4, where our cases that we should be treated in the same way as them, then what distinguishes us from those victims of trafficking who are within paragraph 4, that is, victims of trafficking who have unspent convictions for non-custodial offences and so forth, is that we are subject to offences or unspent convictions for offences that are identified in paragraph 3. So the question is, in that situation, is being subject to an unspent conviction as set out in paragraph 3 a status? Well, being subject to an unspent conviction is unquestionably a status. Being subject to an unspent conviction, yes, it's done to you, but it has numerous implications, which we've highlighted and been through in our case. What distinguishes those in paragraph 3 is that their unspent convictions are those that have been identified and set out in the Rehabilitation of Offenders Act. I took it, your lordships and my lady, to it earlier, carrying certain periods by reference to the nature of the sentence that you received. So that's what distinguishes them from those in paragraph 4. And that distinction is impossible to distinguish from the situation of a prisoner subject to a 15-year sentence. That is, the prisoner who in Clift and the United Kingdom, the European Court of Human Rights said, had a status. So the status comes from being an individual who is subject to an unspent conviction of the type identified and for the length identified. And then what distinguishes them from paragraph 4 individuals is the particular unspent conviction they have, the particular length of that unspent conviction by reference to the provisions of the Rehabilitation of Offenders Act. And as I said, that is totally indistinguishable. And I think that's probably made best exemplified by Lord Mance at paragraph 231, page 2462 in Stott. Here, he's trying to look at, and Mr. Collins took us to part of it, the distinction between somebody's status really being nothing other than what they have done and the situation of a prisoner. And this, it's what it says at the top of page 2462. Problems have arisen from attempts to extend the application of such a proposition to cases beyond its scope. This is, I think, the root of the third difficulty expressed by Lady Black in the first sentence of paragraph 74 of her judgment. There is no reason why a person may not be identified as having a particular status when the or an aim is to discriminate against him in some respect on the ground of that status. Thus, in Clift, the categorisation of Mr. Clift as a prisoner serving a sentence of more than 15 years imprisonment, a bright line distinction clearly associated in the legislature's mind with a significantly higher level of risk, was with a view to the discriminatory treatment about which Mr. Clift complains. It meant that he would receive less favourable treatment as regards early release than life prisoners presenting on their face an even greater risk, and also B, as regards prisoners serving sentences of less than 15 years, since his release would be the subject to approval by the Secretary of State, who could contribute nothing relevant to any evaluation of the continuing risk. It's, to my mind, unsurprising that such categorisation was in these circumstances regarded as giving Mr. Clift a relevant status. It was common ground in Clift that being a prisoner with a status was a status. It was a short step from that in the circumstances to accepting that a particular type of prisoner, namely one serving a determinate sentence of 15 years or more and viewed accordingly as presenting a particular risk, could also be identified as a status. Now, that's exactly the same here. So being an individual with an unspent conviction is a status. It is but a short step from seeing that those individuals who are subject to the category, the paragraph 3 convictions, the more serious ones, also have a status. And what category 3 is doing, paragraph 3 is doing, is distinguishing them for the purposes of the application of the scheme. This is absolutely identical, and in Clift, there is no question that being a prisoner with a 15-year sentence of imprisonment was a relevant status, and we know from Stott that the Supreme Court followed Clift. So there is no basis to distinguish, and that brings us to Doherty as well, because here it could be said that what Lord Mance is saying is that insofar as the discrimination, or rather the status of which, the treatment of which complaint is made creates the status in question, then according to Lord Mance, that does not mean that there is thereby no relevant status for the purpose of the convention. And that is what he is saying in my submission. It's consistent and faithful to what the Strasbourg court themselves said. You have to look at all the circumstances. And he provides an extremely cogent explanation for why you cannot have a rigid rule to the effect that it is never possible for a status to be constructed out of the treatment of which discrimination is, or the complaint of discrimination is made. And
Mrs. Kaufman, you've now run over by nearly 10 minutes.
I'm so sorry, my lord. Yes, I will then have to stop. I apologise. I'd lost track of the time.
No, I'm afraid that we are going to have to draw stumps at this point. We're very grateful to Council for your submissions. We will reflect on the matter and we will hand down our judgment in due course. Thank you.
I'm so sorry also about the relief. We have sent that through to the court, and we will reflect on it further, and if necessary, make a further, if it seems necessary, provide a further draft in support of our submission that it isn't contrary to the statutory scheme to read words in.
Yes, thank you very much. Thank you for that. Good. That concludes the hearing. The hearing is now adjourned. Thank you very much indeed.